SJC-13542, Kathleen Vita versus New England Baptist Hospital et al.
Counsel, will you help me with the pronunciation of your last name?
I'd be happy to, Your Honor. I've been doing that since first grade with teachers. David Gayshock.
Great, thank you. Attorney Geisha.
Okay, please, the court, Madam Chief Justice. My name is David Gayshock. With my colleague Annabelle Rodriguez, I have the honor here to represent two leading Boston public charities and medical institutions, Beth Israel Deaconess Medical Center and New England Baptist Hospital. But as we've briefed, what is before the court here, the stakes stretch far beyond those two institutions. Here are just four, quickly, among the many reasons why that plaintiff must demonstrate, the four among many things plaintiffs must demonstrate in order for the court to sustain the trial court's ruling and to rule for the plaintiffs. First, that despite its text and legislative history, the general court intended this statute not just to cover private conversations between individuals, but to be broad enough to cover internet browsing in 2024. Second, simultaneously, that the general court intended the ordinary course of business exception to be narrow and to be stuck in 1968 telephone and telegraph technology, such that that balance would disappear over time. Third, that both of these things are so clear and so unambiguous that the Commonwealth's well-established rule of lenity does not have any application here. And fourth, that the massive civil liability and criminal exposure associated with ubiquitous 21st century website technology that would be the natural outcome of plaintiffs' approach to the Wiretap Act is not absurd or unreasonable or unforeseen, but instead intended by the general court.
Let me ask you about the intercepting device argument that's raised in this case. How does that reconcile with our holding in the Moody case, where we allowed cell phones and text messages through digital means or through the atmosphere to be covered? You know, wiretaps used to be tapping of a wire with alligator clips and all that, and eavesdropping was done by bugs back in the day. That's not the day anymore. We do, police and other people intercept things digitally. So in Moody, we kind of said that. Why is code different than what we said in Moody?
So we would argue it's not the code, Justice Gaziano, but instead it's the nature of the supposed communication, in air quotes, that's being supposedly intercepted. In Moody, all the court did was extend to the natural, direct successors to what the general court clearly had in mind in 1968. The general court clearly had landline phone conversations in mind, and Moody said cell phone conversations are just the 2013 at that point equivalent.
What's the device that's used to intercept a cell phone call?
In this case, it could be
Moody.
In Moody, I think it was a warranted tap at the communications carrier level at that point, because there's some wire transmission in between the cell phone tower pieces of that call that goes through, and the court noted there was at least some involvement of wires there. But I think the broader common sense interpretation of Moody is text messages are the functional equivalent right now of what telegrams were in 1968.
So, sorry, oh, go ahead.
I'm sorry, just one more question for me, maybe. In this case, we talk about browsing, and I know that the allegations are general. Is this all or nothing? I mean, if someone goes on the BI website and types in a query and wants a response back, is that covered?
So we would argue it's not, because it's not an interpersonal conversation that's being recorded or being listened to.
Where?
Where's the interpersonal part of the statute? Thank you, I'm sorry.
Happy to answer that.
Could I just follow up on Justice Gaziano's original question? So he asked you, he asked you about interception device and, essentially asking why is that standard met here? You then immediately pivoted to talking about communication. I do not read your brief as really making much of an argument that there's not an interception device here, although some of the amici are arguing that point. Are you indeed really focusing your argument on the wire communication piece and not really contesting that there is an interception device?
That's partially correct, Justice Stewart. I think the one caveat I would add is because the ordinary course of business exception is part of the intercepting device definition, we are contesting it in that regard, but we're not contesting the hardware-software distinction that's being made here in terms of just the pure technological advance. It's the nature of the communication and the fact that it was done, in this case, quite clearly in the ordinary course of business, that are the basis of our argument.
Why is communication interpersonal? I mean, I just don't understand that argument. Why does it have to be person to person, and where is that in the statutory text?
So it's in the statutory text at least once, and that's at section 99F2E, and that's where the general court wrote a statement that the oral or wire communications sought, this is in the case of a warrant application, are material to a particularly described investigation, et cetera, and that, quote, such conversations, end quote, are not legally privileged.
Well, why can't there be a conversation with the business?
Because it's not a conversation. This is like looking at a catalog, Justice Gaziano, or looking at a pamphlet. This is all pre-printed, pre-generated content that is on the website, that just like one would look in the index of a catalog.
Aren't those called chats online?
Yeah, that's the query I asked about.
Mm-hmm.
So if there's a question box and you query, I have a problem with my knee pain, and someone's going to come back and answer you. Isn't that a conversation that's not personal?
That might be, but that's not within the scope of the plaintiff's allegations here. The plaintiff has only alleged that she browsed the website to review pre-existing content, not a chat function, not something that's generating new content.
That's why I asked whether this was all or nothing.
Yeah.
Can I follow up on that? Oh.
No, go ahead.
Can I follow up on that? I think it's paragraph 10, if I'm not mistaken, of the complaint. It's either 10 or 11 is the one place that I saw in the complaint, although I'll definitely follow up with the plaintiff on this, where there was specific conduct of this plaintiff and specific interactions identified. And I did not read in that paragraph something having to do with a form of interaction that's heavily focused on in their brief, which is a request on the website for an appointment. And we encounter these things all the time. It's a form, like your name, what's your problem? Like it could be a doctor, it could be any kind of business. And you write them a little message, and it's clearly what they are using instead of email, right? Instead of giving you an email address, they give you a form and you fill it out and you write them a message. And I think that I'd be interested to hear your thoughts about why that does not fall underneath your definition of communication, because you are communicating, you are writing a message to a business, and you are expecting that they are going to write back to you in particular about your issue.
So that is probably about as close hypothetically as one could get in this context, but just as Your Honor pointed out, it's not within the scope of what plaintiff alleges that she did in this case, which is all of her allegations, and I agree, they are all in paragraph 10. There are no other allegations in her complaint about what she claimed to have done. In fact, there are more disclaimers of what she didn't do in footnotes of her complaints than there are allegations about what she specifically did. But all she alleges is that she went, sought out, and received pre-existing content.
So, but can you address my hypothetical about putting that to the side and understanding your position on that? If you have a form that asks that where a website user fills out the form requesting an appointment, would you say that that would be a communication within the meaning of your definition of communication?
That is probably, that's close to the line at least. That's as close as it gets because it's asking for pre-existing content and a communication back. I don't think we're there yet because of the scope of what this, remember, everything the court finds to be within scope here for civil purposes is in scope for all of the felony.
What's the
provisions
difference
do.
between that and a text message?
Because the difference between that and a text message is it's a pre-filled form that's merely asking someone
So
to
I
call
ask for
back.
information, and then I get information back. The definition of conversations in Rivera, in the footnote in Rivera, it sounds like a conversation to me.
I very much agree that it's about as close as we come here. It is right at the line.
Range of observations, opinions, and ideas.
Yeah. But I do want to stress that the plaintiff's claims are, first, she doesn't allege that she actually did that. But second, her claims are much, much broader than that limited example. That's a hand-picked strategic example for briefing purposes. Her claims are, her proposed class is,
We get what
Yeah.
paragraph
Exactly.
10 says. You don't
So
have to go through it.
when she, I mean, we've got another plaintiff who goes onto your website and says, I'm looking at all the breast cancer doctors. That's not an inquiry, or, I mean, it's revealing thought process, but maybe it's not a communication, but it's the beginning. It's communicating information that obviously is valuable to Beth Israel and also these third parties, right?
it's going on the website to look at pre-existing content that exists there. It's like thumbing through a directory or a catalog in 1968
Right.
of content that already exists. If someone sitting in a hospital waiting room were flipping through a doctor's directory or a Best Doctors Boston Magazine issue, and surveillance footage, and the surveillance camera observed that flipping through, that wouldn't be a Wiretap Act violation. This isn't either.
Can I ask you about your telephone telegraph exemption? And you say it's not stuck on telephone and telegraph. But when you go on in section D, there are other exemptions that are specific, right? There's a switchboard operator, intercom system, financial trades and transactions. Why can't we just read the words as they lay and say it's telephone and telegraph?
A couple of reasons, Your Honor. First, because that's not what, for instance, the appeals court has done in the past. Slightly different words of that same exception, but in Dillon versus MBTA, for example, the appeals court's whole rationale, same kind of claim as here, right? Plaintiffs seeking damages on behalf of a putative class, claiming that, look, the statute's literal language says X. It's got to be, in this case, equipment from a communications common carrier.
And they got it from somebody else?
They got it, and in Dillon, they got it undisputedly from a third party. Okay. And what the appeals court said was, we see that that's the language, but that would be an absurd result.
But that was specifically absurd because of the breakup of the monopoly of the bells, right? Like they read common carrier a little more broadly to include not just the monopoly.
There's still the telephone.
I mean, I think we read it differently. It was a specifically designed device that stood alone from telephones, was not required to be part of a telephone system, that was only for recording calls. In O'Sullivan v. 9X, this court's decision a couple years earlier, it was a software program that recorded sales and marketing calls by 9X to its subscribers trying to sell additional services. That was also the ordinary course of business. Now, if...
How is this, go ahead. How is this the ordinary course of business, though? Selling information to an ad agency or Google about what potential patients are interested in on your website, how is that part of a hospital's business? Ordinary course of business. Doesn't seem like ordinary to me. It seems like they're getting into a for-profit kind of operation.
So I think we would respectfully disagree with the characterization of selling this information to Google or Facebook.
You're giving this to Google so that they know how to market people. That's not part of the hospital's job. I take it the hospital's getting paid to give this data to the advertising people at Google. What's that have to do with your job?
So the hospital was licensing software at the time to do analytics and marketing on its own and communications for its own website.
But that's what you say in that. You say it's going to be used for security purposes and to enhance your own services, but it's actually being sold to a third party. I take it to make money. That's not what a hospital does it? It's not what a hospital normally does.
So we're not getting paid for it. Now, there is an allegation that we're getting the software provided for free, but we're not getting paid by Google or
Don't
Facebook.
make any money off of this, and you're giving out all this information?
I think we're using analytics technology as more than a dozen other hospitals in the Commonwealth
I'm not saying you're any different.
Yeah, and 99% of the
I just don't
hospitals.
know. To me, the ordinary course of a hospital's business is taking care of patients. I don't understand what this is.
But we're using this is the same technology that's sitting on mass.gov right now, including this court's website. So we're not getting paid to sell data here.
Yeah, but when people ask for the SJC docket, they don't get ads for gavels, right?
They might if that were commercially. Google Analytics and Facebook technology have long been sitting on all of and specific parts of mass.gov, including the state's hospitals, including the state's, the substance abuse resources.
I take it the notice that they put up, I hope it was broader than the notice you put up, which is we're only going to use this for security and blankety blank, and only our own internal third-party provider. It doesn't mention Google and ad tech or whatever they are.
So it's funny you mentioned that, Justice Kafker, because the notice at the time when this lawsuit was filed was very similar. Not word for word identical, but the mass.gov notice and our notices at the time were very similar. Unfortunately, plaintiffs have chosen to try to hit us over the head.
We can't decide this case based on sort of the practical impact on others, and we should all check our website. But in any event, I guess to that question about the practical implications of the holding here, one of the amici suggests, fine, literally the wiretap statute may read on this conduct, but please, SJC, make this a prospective decision. And I'm wondering, what is your thoughts on that?
So our position is that the Wiretap Act doesn't apply.
Right,
and
but
that
assuming it does, because literally it reads on this conduct, what is your position on that particular argument about making this ruling prospective?
We would certainly urge, if the court does not accept our primary argument, that the court indeed do that.
And what would be the legal authority for doing that?
I would have to defer back to the briefing and
the
the
amici?
same amicus brief that Your Honor is referring to.
Okay, thank
because
you.
That's not part of our argument. Unless the court has any further questions, we'll stand on our briefs. Thank you.
Thanks very much. Okay, Attorney Vallely.
May it please the court, Patrick Vallely on behalf of the plaintiff, Kathleen Vita. This case is about hospitals that allowed technology companies to eavesdrop on highly sensitive communications between healthcare consumers and their medical providers without...
Let me ask you about any communication, how broadly that should be read. As counsel pointed out, when I look at 99 subsection F on the search warrant requirements, it talks about oral or wire communications, and this is a wire communication. And then it says such conversations. So it terms them as a conversation. And then when I look at Rainey and Rivera, both those cases say the statute protects private conversations. So given what we said about the statute protecting private conversations, and given that the language in the statute also uses the word conversations, is this a conversation?
The short answer is yes, as I think well, let's take a step back first. The key operative provisions of this statute are largely found in the definitions. And in particular, the definition we focus on is the definition of wire communication. In wire communication, the definition refers to transmissions between points of origin and points of reception. That language and the operative definitions that apply in this case fall squarely within exactly what the internet is.
We've had the booking room cases, we've had the body-worn camera cases, we've had other cases where in Rainey where we had the robbery of the store in the community. We said, we know it says any communication, but we need to look at the purpose of the statute, and it doesn't cover everything that's said.
Well, I think it's certainly accurate that the statute covers conversations. The question that the defendants are posing through their arguments is whether it's limited to interpersonal conversations. And even though the court at certain times has used the word conversations to describe a...
But are you conceding that any communication means any conversation?
I'm certainly not conceding that the word communication is limited to interpersonal conversations.
All right,
We
what about the
reject that
second, what
argument.
about the second word? Is it limited to conversations?
It depends necessarily on the meaning of that word. If the defendants are correct that conversations by definition involves only communications between individuals, then we would reject that
Okay,
proposition.
then answer my question. Does it entail necessarily conversations?
I don't think the statute by its terms is limited to conversations. I think the operative definitions uses the word communications, which is arguably broader.
Right, then why did the legislature in section F use the word conversation?
Well, it's one word in the statute. The statute uses the word communications a few dozen times and uses the word conversation once. I think it would read a lot into that one provision, which relates to one procedural
But counsel, it's
issue.
not just that one word though, right? It's also the concern with eavesdropping, which is throughout the statute, right? And in the preamble and in the legislative history. And eavesdropping has a really common meaning, right? Like eavesdropping is a long-standing pre-advanced technology era concept where two people are having a conversation and then a person is listening in. And this statute was designed because the legislature was concerned that there were new technologically advanced ways of eavesdropping, and they were trying to stop that. Correct?
I think that's correct, and I think our case very much does allege eavesdropping as that word is ordinarily used. Now, true, back in 1968, the legislature didn't specifically anticipate the internet as a technology, but what it made very clear, both in the terms of the statute and the preamble, is that it understood that new technologies would continue to be developed over the years that pose threats to the privacy of citizens of the Commonwealth. And although it didn't know at the time exactly what those technologies would be, it intended to draft a broad statute that would cover those future technologies. And you see that in the definition of wire communication I mentioned a moment ago that refers to transmissions between points of origin and points of reception. You see that in this court's decision in Moody, that definition that I just quoted to you from wire communication is broad enough to include non-oral electronic transmission.
So given that breadth that the legislature was clairvoyant in seeing and the dangers that they wanted to protect citizens from, why would we read telephone and telegraph so literally in the exception that the defendants want to take advantage of?
Well, first, the plain terms dictate that the exception is narrower than the general prohibition. The general prohibition applies broadly to intercepting devices, and the exception applies more narrowly to a subset of those devices.
And so you think
specifically-
it was purposeful that the legislature limited itself to 1960 era technology, even though they were clairvoyant about future technologies and the interception of those?
Well, there certainly have been technologies that have developed since 1968 that would fall within
Clearly.
the conversation of that would fall within the definition of a telephone. I would concede, for example, that cellular telephones, although they did not exist in 1968, would qualify for the telephone exemption if there are other requirements of the exemption are met. If it's in fact telephone equipment. But even on that issue, the case law is clear, and frankly, it's a little bit better developed in the federal courts, which construe the language comes directly from the federal act. It's not different. That not all interceptions that involve telephones necessarily qualify for the exemption. Rather, the intercepting device itself must be a form of telephone equipment or some kind of infrastructure of the telephone system.
Are there any limiting principles? Because, I mean, if browsing is a communication, and any device, any software device that tracks it is covered. I mean, I'm just trying to understand this thing is just, everybody's violating it. why isn't, I mean, I'm just trying to understand, is there a limiting principle here, and what is it?
Well, focusing on what a communication is. A communication at its core is an interaction between two parties. It's an exchange of information between two parties. And even on what the defendants call informational or parts of the website, when you interact with the website, when you click on a link, you're requesting information on a topic, and then the business through the website is responding to your request by providing that
Well, the business
information.
isn't doing anything. The business could be asleep, right? The business just has a website that is already set up with information on it that people can access, correct?
So the website, though, is set up by people, right?
Well, the website is set up by people, and I disagree that the business has to have some kind of conscious, in the human sense of consciousness, awareness of the communication for it to be a communication. And in fact,
Does it at least have to be a two-way communication? It doesn't have to be a two-way communication? I mean, you're communicating, I understand your client is communicating information to Beth Israel Deaconess, but if they don't respond back, is that a communication? I'm just trying to understand that.
Well, in general, unless the website is down or not functioning, the business does respond back through the website. The website user requests information, and the website responds to that by providing the information requested.
So does there have to be a return? Literally, I mean, it could be AI, but does there have to be something coming back from Beth Israel? Or is it just anytime you start browsing, you're covered?
Well, I think anytime you're browsing and you're clicking on links and requesting information and the website is loading successfully,
okay.
the response is a communication, and
There
it
could be-
is an interaction.
So I want to find out what the hours of operation of the gift shop are, and I go on the website. That's a communication?
If you're requesting information from the business and the business is responding, that would be a communication.
Is that a conversation too?
Is it a conversation? I believe it would be. Again,
Okay, so they've posted the hours of operation, because I'm going to go visit my mother. I want to see if I can buy her a plant. What's the conversation?
The conversation is you have requested from the business information about their business, and the business has responded with that information. I agree.
Does communication have to be a conversation? I guess I'm wondering, isn't a conversation, the back and forth between two individuals, a subset of communications which has a broader definition of an exchange of ideas?
I agree with Your Honor that the word communication is arguably broader than conversation, and the operative provisions of the statute use the word communication.
What do we do with our case law that says it covers private conversations?
I think that the case law doesn't say it's limited to private conversations. In fact, several cases have rejected that proposition, particularly when Your Honor used the word private, that there's any limitation such as found in other jurisdictions, wiretap laws, that there's some kind of reasonable expectation of privacy requirement. But setting that issue aside, I agree that the operative provisions here refer to communications, and communications is a broader term, particularly the term wire communications, which refers to transmissions between points of origin and points of reception, which is a much broader and concept that's broader than a conversation and fits perfectly with what the internet is.
So this lawsuit is a little surprising, I think, to most website developers and owners. Is there a response, and I'll give you the opportunity, to the idea that if you're right, that this should be a prospective holding? I didn't see it in your reply to the amici, so I'm giving you the opportunity to do it here.
Yes, I think a core part of that response is a recognition that when the four Superior Court justices that have upheld these claims, they were not writing on a blank slate. I think the most notable authority on that issue is the First Circuit's decision in PharmaTrack. And that decision is remarkable that when you look at the facts of that case, even before Google and Facebook were household names, the technology at issue in PharmaTrack was practically identical to the technology at issue
But
here.
importantly, the statute was very different, was it not?
The federal statute in some respects is less protective of privacy than the Massachusetts statute. The Massachusetts statute imposes stricter regulation on businesses than the federal law. So But the short answer is that from PharmaTrack forward, which was in 2003, more than 20 years ago, businesses were on notice that using these kinds of tracking technologies on websites, those technologies created communications that fell within the scope of the wiretap law. And importantly, even though that decision is now 20 years ago, the Republic has not failed. Businesses have not gone out of business. In fact, they've continued to use ad tech, and most of them lawfully so. And defendant's own amicus, the National Retail Federation, explains a large part about why that is, about why the Republic did not fail after PharmaTrack. And that is that, according to their own amicus, the vast majority of website owners disclose the ad tech, and therefore do not face liability under the statute.
Can I ask about that? So one of the arguments that opposing counsel makes is, you're being monitored. The cookies and the notice says there's monitoring going on here by our third party. They may be misrepresenting exactly what they're doing, but this is not a case where you're being eavesdropped on. You know that this is being monitored. They say it up front. Do you have to identify everybody who's monitoring you? This is not a surprise that they are keeping track of this. They say it, right, on the website.
I would respectfully disagree. I think what they disclose on their website is that that their web server maintains logs.
No, I thought it's much more explicit than that. It says that we're sharing this with our third-party administrator for security and other purposes. I read the notice. So you're being eavesdropped on.
I would respectfully reject the proposition that their disclosure
You're being monitored.
that discloses any eavesdropping. They recognize, as is true among many modern websites, that websites are often hosted by third-party providers.
Isn't the difference that the disclosure says it's anonymous and in fact it isn't?
I think those allegations are significant, but I think also the allegations are very specific. There's a paragraph referring explicitly to their recording of website activity, and they state in very explicit terms, we will not share this information with outside parties. It cannot be the case under the secrecy prong of this statute that when you have a statement like that in your policy that frankly is a lie to consumers about what they're doing with this data, that form of eavesdropping is non-secret.
Well, it's contradictory, right? Because it also says we share information with our, I think it's third-party service providers or something like that. It does say that, does it not?
Yes, but in that earlier in that same sentence, it makes clear that what it's referring to are web servers. So it's their third-party web server providers. So you have to look at, you can't just take a few words out of context. The context of that is that they limit any recording to their web server logs, whether that's the business itself possessing the web servers or a third party. And beyond that, they engage in no sharing or permit no eavesdropping by any outside organizations, which is a statement that's categorically false and rendered the interception secret.
If it's okay, could I just ask you to respond to something we were discussing earlier, which is what I'll call the paragraph 10 issue? I just want to give you a chance to respond to the concern that your brief discusses a whole variety of different kinds of ways that the wiretap app could be violated in this general realm. But then paragraph 10 for this plaintiff only alleges certain kinds of actions that she took with respect to the website and does not address, for example, filling out forms requesting an appointment and so forth. So can you respond to Justice Gaziano's question about, is this an all or nothing question? And I'm not asking about standing. This is separate from that.
Yes, so I do recognize that in our complaint, we describe our plaintiff's interaction with the website in fairly general terms. In part, remember, the object of this lawsuit is to protect privacy, so we did not want to go through and disclose her medical conditions in a publicly filed complaint. But we do describe, and I'm referring to the Beth Israel complaint, paragraph 10 in particular, how she used the website to, quote, search for information on particular symptoms, conditions, and medical procedures, close quote, and how she also uses the website to obtain medical records. And I agree that there are additional examples that we give in defining and explaining our class claims in our complaint that are additional categories of pages that are on the page that the tracking technologies were also on, that are, and we're not saying our plaintiff visited every page on the website, but certainly meets a notice pleading standard and informing them of the conduct. And per my argument,
You're not arguing that the medical records information was transferred to a third party, right? I thought that that's clearly not the case. That's a different part of the website.
The substance of the medical records, the substance of the medical records does not appear, based on our current investigation, that was intercepted, although I do have to admit that the degree to which any tracking technologies may have been used earlier in the class period within the patient portal is a fact we don't know one way or the other. I agree we don't affirmatively allege it, but there's no way after the fact to go back and recreate it, just the nature of what versions of web pages are archived and which are not.
So going forward, anybody who goes online, as long as it's disclosed, they won't violate the statute, but there's not going to be any chance to opt out, right? I mean, it's disclosed and that's the end of it.
I agree that under the Massachusetts Act in particular, that the way the secrecy element reads, it does not require affirmative consent. A person can effectively deny consent by stopping using the website. But if a website owner discloses in clear terms the technologies and the interceptions they create, then there would be no violation.
Okay.
Unless anyone has any further questions, I see my time has expired.